Welcome to Strategic Insights, guidance for life's most important decisions with attorney Alan Eighmey.
Welcome back to Strategic Insights, guidance for life's most important decisions with estate planning attorney Alan Eighmey. Alan is the managing attorney of Strategic Legal Group, where he helps Californians plan with confidence and protect their families from legal and financial uncertainty. I'm Evan Mack, and today we're talking about probate in California. Alan will explain what it is, why it matters, and how you can avoid it. This is Understanding Probate in California and How to Avoid It. Alan, hello, welcome back.
Hey, Evan, how's it going this morning?
Oh, it's going well. Now, to start, can you break down to people what is probate and what does the process look like in California?
Yeah, so people get confused about probate and what it is, but it's pretty simple actually. Um, all probate is it allows a living person to sign the name for a deceased person. So if something happened to me and I passed away and my son wanted to sell my house, he obviously couldn't sign my name on the deed and the papers to do the transfer. And, seeing how doing the whole weekend at Bernie's thing is illegal, then
That's one of my favorite movies ever. But go ahead.
then he would have to get the court's permission to be able to sign my name. And so basically, it's just a court supervision over allowing one person to sign for another person. And because the court is involved in this whole process, they want to make sure that everything is done in just a strong and legal manner, of course. And so they have all these different steps that they make the administrator or the executor jump through to do the probate.
So why is probate such a concern for families, though? Like, is it mostly about delays, cost, or maybe all of the above?
Yeah, it's really about all of the above. So, the probate process is a long process. It takes about a year or more sometimes to do. It oftentimes can delay families from getting at some of the assets that the loved one had to help during that traumatic time when someone has passed away. And it's also kind of a reminder for that whole year period, about that person's death and passing. So it really can take a mental toll on the family and kind of keep them from moving on with their life and after the death of a loved one.
How long does the probate process usually take in Cali, and what kind of expenses are involved?
Yeah, so the probate process takes about a year in California, sometimes longer, depending upon the court that you're at. Some courts are more impacted than others, so it can take even longer than a year. The other thing with the probate process is the expense. California, the fees are statutory. So what that means, it's everybody kind of charges the same fee, and the court charges the same fee, and it's a percentage based upon the value of the estate. So the way that breakdown is, it's 4% of the first 100,000, 3% of the next 100,000, 2% of the following 800,000, and basically 1% of everything over that. So if somebody has an estate of $500,000, that percentage adds up to about $13,000 in administrative fees, $13,000 in executor fees, and then other filing fees and court costs and those things is another $3,000 to $4,000. So you're talking about $30,000 to probate an estate that's worth $500,000. And the state's pretty tricky on what they do that because it's based upon the value of the estate. So if you have a home that's worth $400,000, but you still owe $350,000 on it, for probate purposes, they're looking at that $400,000 number, not whatever equity you might have in there. So.
What types of assets automatically go through probate if someone dies without that plan in place?
So the assets that kind of go through probate are, if there's a home or real estate and that real estate hasn't been, set up to transfer in any other way, then it would go through probate. You're talking your bank accounts, individual bank accounts that don't have beneficiaries set up on there. Even we've had a lot of issues with 401ks and employer plans that the employee never set up beneficiaries, and so all of a sudden those have to go through probate. And we've had a couple younger clients pass away unexpectedly. They've had pretty decent jobs at where employers provided a nice life benefit. But when they started, because you're younger, you're not thinking of these things, right? Your employer gives you all these forms and asks you, oh yeah, who do you want for the beneficiary on this? And you're like, oh, I'll get to that later, right?
Yep.
And then, later never comes. So, even those assets have to get probated, and it makes it difficult for families to kind of, navigate and mentally and just kind of get through and over all of that during those trying times if they have to go through a whole probate process. So.
So, Alan, is there any misconceptions out there that people might have, like assuming, a wills that avoids probate, or anything that comes to mind when it comes to this process?
Yeah, so a lot of people think that you have to go through probate if you don't have a will, but in California, that's not true. Even individuals with a will have to go through that whole probate process, and again, it causes additional expenses for the estate, and it just lengthens out the process that people have to deal with getting through that whole trying time. So.
Hmm. How can setting up a trust help families avoid probate altogether?
Yeah, so a trust is the one item in California where it really avoids probate. And what a trust is I like to tell people that a trust is almost like setting up your own company or corporation. And when you set up a trust, what you're doing is you're setting up a entity that you title all your assets in. So, in my case, my home would be in my trust's name. I'd be trustee of the trust so I can manage and control it. But if something happens to me and I pass away, I've already picked what they call a successor trustee, much like a vice president of the company, that can come in and just kind of take over without having to go through that whole probate process. And it really streamlines everything and makes it easier for the family to deal with.
Hmm. What happens if someone owns property in more than one state? Is that added to the probate risk?
Yeah, it does. So, a property that's owned in multiple states, if you have a trust and you put that property in a trust, and no matter what state your trust is in, it still will go through that trust process and avoid the probate. But if you own property in multiple states and you die either intestate or with just a will, you could have to do two probates, one in California and one in Texas where you own the other property. And then suddenly now you're not dealing with just one legal issue. You're dealing with two attorneys, fees, all of those additional things. So it really can cause a lot of headache for heirs who own, who's beneficiaries who are left properties that in multiple states. So.
Hmm. Are there tools beyond the trust that help avoid probate, like transfer on death deeds or beneficiary designations?
Yeah, so you can use transfer on death deeds and beneficiary designations to transfer property in California. The issue is it doesn't give you some of the creditor protections that you possibly would get through a trust, because if you inherit a property that way and there are creditors, the creditors can oftentimes lien those properties and collect from those, even though you've inherited them from someone else. So a trust is usually the better and cleaner way to kind of do the transfers on that. But if you have a small estate, possibly a transfer on trust deed or a joint tenancy can be the way to go. I don't recommend putting a property in joint tenancy with another person, oftentimes because if something happens and that other person, possibly they're married, they get a divorce all of a sudden, and they had the joint and the you had your property in joint tenancy with possibly mom, you get a divorce, all of a sudden the future ex is going to say, well, you own half, this property over here as well, even though it was just mom's property, and that can get tied up in that and get really messy as well. So a trust could avoid all of those kinds of things.
Yeah. And Alan, for someone listening who wants to keep their family out of court, what's the first step they should take?
They should talk with an attorney who does trusts and see what they need to do to get those set up. Here at Strategic Legal, we try to make that process as simple as streamlined as possible. The amount of information that you need to give us, we try to keep it at a minimum so that we can give you and still give you the best plan possible, and make it as easy for your heirs as we possibly can.
Amazing. Alan, thanks for your time.
Thank you.
All righty. And thank you all for joining us on Strategic Insights. If you want to protect your family from the time, cost, and stress of probate, don't wait. Visit strategic-law.com to schedule a consultation with Alan. Also, be sure to like, subscribe, and leave a review if you found today's episode helpful. Thank you so much. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.